Let's turn straight there then to our top political story, where a Delhi court today refused to take cognizance of the controversial Enforcement Directorate charge sheet against Rahul Gandhi and his mother Sonia Gandhi, among others, in the National Herald case, where the Gandhis were accused of money laundering by the Enforcement Directorate. Today, this was a major relief for the Gandhis and a setback of sorts for the Enforcement Directorate, even though the agency sources claim that the issue is purely procedural. The merits of the case have not been decided and they will appeal against the Delhi court verdict. What does this all mean for the Congress's first family? That's our top focus. Take a look first at this report.
A big relief for Sonia Gandhi and Rahul Gandhi in the National Herald takeover case. A Delhi court has refused to take cognizance of the money laundering charge sheet filed by Enforcement Directorate against the Congress leaders in the case. The Rouse Avenue Court raised the complaint filed by the ED under the Prevention of Money Laundering Act was not maintainable, as it was based on a private complaint filed rather than a formal FIR. The ED had acted on a complaint by former BJP MP Subramanian Swamy. Special Judge Vishal Gogne noted that the Economic Offences wing of the Delhi Police has filed an FIR in the case. ED sources said the court's order was based on technical grounds and did not address the merits of the case. Sources say that with an FIR now registered by the Delhi Police, the ED will continue its probe and file a fresh charge sheet. The ED alleges that the takeover of National Herald by a company promoted by the Gandhis is a clear instance of money laundering. The central agency is likely to challenge the court order. The Congress hailed the Delhi court's order.
Today, the judgment is significant because cognizance is the lowest form of dealing with a case. It is very easy to take cognizance of a case. It means that the case is not worth taking cognizance of. And here you see the amount of the halla gulla shor machaya hai. BJP has made a superstructure of exaggeration.
जो उन्हें करना है वो करते रहें। हकीकत ये है कि नेशनल हेरल्ड इस राष्ट्र की एक धरोहर है, इट्स अ हेरिटेज। उसके खिलाफ जो साजिशें रची जाएंगी, अंग्रेजों ने भी रची थी, वो नहीं सफल हुए, इन लोगों ने भी रची, ये भी नहीं सफल होंगे।
The BJP described the ruling as temporary relief for the Gandhis.
ये अभी टेम्पररी उनको राहत अपने भले महसूस करें, लेकिन जब फाइनल फैसला आएगा तो वो कांग्रेस के नेताओं ने जिन लोगों ने घोटाला किया है, ये फाइनल फैसला उनके विरुद्ध जाना ही है।
Congress party of course saying that this is a big win, that there are no evidences, no base to the charges against the Gandhis and the Congress party in the National Herald case. But as a political issue, this will continue as long as the EOW investigation does. In New Delhi, this is Anisha Mathur for India Today.
And my first guest tonight is the lawyer for the Gandhis, senior lawyer, four-time MP of the Congress party, Abhishek Manu Singhvi joins us. Appreciate your joining us, Dr. Singhvi. It appears that while a Delhi court has dismissed the money laundering complaint registered by the ED against the Gandhis in the National Herald case, the court has also made it clear they are not pronouncing on the merits of the case. So is the celebration in the Congress premature that the Gandhis have been let off? Because that is not quite the case.
You judge for yourself, Rajdeep. Let me put it in perspective for your viewers. The judge has refused to take cognizance of the complaint. Cognizance is the lowest form of entertaining something. He has thought it not fit enough even to take cognizance, which is the basic entry point. Point number two, he has in effect said that there is no predicate offense, the underlying main offense, which is the dog, without which the tail cannot wag, because the ED is always a consequential offense. So in the absence of a FIR, which is what the judge has found, there is no consequential ED offense made out. Point number three, the result is that for the last 2-3 years, with 50 hours of interrogation of Rahul Gandhi, with 10 hours of interrogation of a lady like Sonia Gandhi, with all this hullabaloo every day in the press, shooting through every possible channel and newspaper that there is a big scam going on, we now find that all that investigation is on the basis of a non-existent FIR. Number 4, if this judgment, as it stands,
Dr. Singhvi, I must stop. Dr. Singhvi.
Allow me to explain
what
the
court
concept.
seems to be suggesting is procedural because it's based on a private complaint that was filed by Dr. Swami. But the judge observed that the Delhi Police's Economic Offences Wing has since registered an FIR in the matter, and therefore the ED can carry on the investigation based on that FIR.
So therefore, I was just coming to the point. You must first realize that for the last 3 to 4 years, you are going on something which is today being found to be without jurisdiction. The consequence, according to me in law, would be that all that investigation becomes null and void. Now, what will happen in the future will be for us to challenge. We don't know. Today, 2 weeks ago or 1 month ago, they have filed a new FIR. The new FIR is basically the same thing as the old with some few things added. Now, whether that will stand the scrutiny or not will have to be seen. It's open to all our challenges. Cognizance of that is a separate issue. My point is, how is it premature? That means all the hullabaloo you saw on your channels, all the newspaper leaks you saw on the newspapers, all the shouting from the rooftops you saw by the BJP and the government against National Herald, that was all a premature shouting. If that was not premature, why is our celebration premature? Today, it is.
So,
you can always
how does the courts? So, if I may ask you, how do you believe that the court's refusal to take cognizance of the EC's charge sheet, based, of course, on Dr. Swami's complaint, validate your earlier arguments that you've been making about the absence of a predicate offence or the alleged procedural flaws in the National Herald case? Why do you believe this is a victory for you?
Please don't keep calling it procedural. That's your characterization, and it's a mischaracterization. It's highly substantive. Our case was what? That you had an ED barking up a tree for the last 3 or 4 years without the body of the main scheduled offense being there. That's a substantive issue. The first principle of PMLA is that you cannot have a tail, which is the ED consequential offense, wagging without the existence of a dog, which is a predicate offense, the FIR. Now, this court has found that there is no FIR in terms of a requirement of law under the PMLA Act. There has to be a police report, police complaint. There is none. Mr. Subramaniam, Dr. Subramaniam Swami started a private complaint, which most of us tend to forget. He himself got a stay of his own complaint and the proceedings before the magistrate. He got it stayed himself by the High Court. Now, there is nothing on which it could proceed yet. What did you hear politically and legally for the last 3 or 4 years? 56 hours of interrogation of Rahul Gandhi. Mr. Kharge and Madam Sonia Gandhi had hours. That was on what? On the basis of a non-existent FIR. And we are not entitled to tell you that this puts mud on the face of the ED. It makes them look foolish. Now, a month and a half ago, after 4 or 5 years of doing this, they tried to file another FIR, which is a rehash of the old with some very limited new facts. That will take its own course. We will deal with it. I'm sure we'll be able to point out equally.
So you're seemingly
ridiculous gaps.
You're seemingly suggesting this, according to you, this is a classic case of the process being the punishment. You seem to be suggesting this is a classic case of the process being the punishment. The ED sources who are telling us, saying, A, they're going to appeal against this lower court order, and they believe they still have substantial evidence, they claim, to prove money laundering.
So let me answer both your questions. It is certainly process being the punishment. That is the rule in most of these cases, because for the simple reason, Rajdeep, you and I know, the conviction rate in this is abysmally low. So everybody is going to be acquitted, but you harass them because the process is the punishment. That's putting it mildly. Secondly, they will of course appeal. Nobody can prevent their right to appeal, but we are talking as of today. As of today, they have mud on their face because they've been prosecuting. And why were they shouting so much? It is because politically it suits them to say this is a huge scam. Arey bhai, it was a huge scam. You didn't have a FIR on it. You were relying on a private complaint by someone who himself got his own proceeding stayed. Does the ED have to be taught some basic law? And certainly calling it procedural is nothing. That's just a characterization in a self-serving manner. It is a very substantive fatal flaw. Right from the famous case of Vijay Madanlal Chaudhary, which is a basic case, it has been held that without the basic offense of an FIR, you can't have a PMLA offense. Now, I can tell you that this new FIR is also full of flaws, but I'm not at the moment going to reveal to you our strategy or our decision about it. But to say that now everything is hunky-dory because last 4 years are washed off, lack of jurisdiction, the entire investigation goes. What were you investigating, Rajdeep? Your investigation corpus, let's say, is 10 volumes. That 10 volume is based on non-existent FIR. What is the value of that, evidentiary value of that?
Okay, let me leave it there, Dr. Singhvi. You've clearly given your reasons why you believe what's happened today is, to use your words, mud on the face of the Enforcement Directorate, and you seem to suggest it is certainly a vindication of the stand that you've taken. We'll wait and see how that plays out, but for now, for joining us, Dr. Singhvi, appreciate you joining me. Okay, we've heard from the Gandhis' lawyer. Let's go to our political face-off. Raise the big question. Is this a political witch hunt by the Enforcement Directorate, as the Congress claims? Is the process the punishment in most Enforcement Directorate cases? Is the Congress really right to claim vindication? Or is it, as the BJP says, no clean chit for the Congress and the Gandhis? Those are some of the questions I'll raise. I'm joined by Sanju Verma of the BJP's national spokesperson and Mahima Singh of the Congress. Appreciate you joining us on the political face-off. Sanju Verma, it appears that the Delhi court's refusal to take cognizance of the National Herald money laundering case by the ED against the Gandhis is clearly a setback for the Enforcement Directorate. It gives the Congress more ammunition to say this entire case, which is based on a private complaint of November 2012, is simply being used as political vendetta.
You know, Rajdeep, a few things. First and foremost, the Delhi police has already filed an FIR on the 16th of December 2025. And going forward, now the trial will take place on the basis of not a private complaint filed by Mr. Subramaniam Swamy, but on the basis of the FIR filed by Delhi police, point number one. Point number two, the Delhi High Court not taking cognizance is procedural. It is not based on merits of the case. Point number three, just like they say that if you're out on bail, you're neither innocent nor guilty, simply not taking cognizance does not mean that Sonia Gandhi and Rahul Gandhi have been given a clean chit. It simply means that Sonia Gandhi and Rahul Gandhi will continue to face trial, albeit on the basis of the new FIR which has been filed by the Enforcement Directorate.
Ma'am, a new FIR comes in, no, just a minute. A new FIR comes in 13 years after the original private complaint. It almost seems that that the ED didn't have enough to back its original charge of money laundering. Now comes with a new FIR based on what the Delhi Economic Offences Wing has done. It almost seems as if the original case is falling apart 13 years after the private complaint.
You know, Rajdeep, you said at the start you don't want a tutu meme. But I barely spoke for 30 seconds and you could not control yourself. You gave in to the temptation of interjecting me. Please let me complete very humbly. Please let me finish. I just want to tell you, I want to tell Abhishek Manu Singhvi and your audience, which is the biggest stakeholder in these debates, does the charge of conspiracy, criminal conspiracy at that, wide section 120B of the IPC, has that been dismissed by the High Court? No. Under 403 of the IPC, misappropriation of property by Sonia and Rahul Gandhi, has that charge been dismissed by the Delhi High Court? No. The case of cheating under section 420 of the IPC, has the Delhi High Court dismissed that charge? No. And more importantly, under section 406 of the IPC, criminal breach of trust, which is a predicate offense, has the Delhi High Court dismissed that? No. Because I want to end by just saying one thing. In the PMLA under section 2 and 3, if the charge is a predicate offense, then it automatically becomes non-bailable and cognizable. So the Gandhis actually are going to see...
I have to go. I am waiting to see what happens. I've been waiting. Man, I've heard you now. I've heard you patiently. I've been waiting, in fact, patiently for 13 years to see this case reach its logical conclusion. But Mahima Singh, respond to it. I asked this also earlier to Dr. Singhvi. There's a sense that is the Congress being premature in celebrating, given the fact that the merits of the case will continue to be argued, and importantly, the ED says it will carry on with the investigation now based on this new FIR. How do you respond to what you heard just now from Sanju Verma?
Jai Hind, and I think Dr. Singhvi had responded to your query befittingly. But every time I see BJP spokespersons speak on these issues, it seems like they're the spokespersons of the ED and EC and the other institutions, constitutional bodies, which the BJP has, in self-proclamation, they have assumed these institutions, the precious constitutional institutions of this country, to be their pawns. But it's only a matter of time. I must say that today a new era has begun. By this order that has come out from a district court, I would say that end of vendetta politics has begun, and I can say it with utter confidence. And yes, our celebration is not premature. We must ask a few questions today of ourselves and of those who have been claiming that the Congress has Congress leaders are involved in these cases. Now we must ask that why was the BJP questioning when we came out in protest when our leaders were summoned? Because now the district court has actually refused to take cognizance of the proceedings itself. Malafide is being seen outrightly. We must also question why a complainant, Mr.
The court did not use the word malafide, ma'am. That's your word. Court did not use the word malafide. That's your word. Court has said on procedural grounds.
But the court has refused to take cognizance of this case after 12 years. And at whose cost? Rajdeep, we must ask that question. At the cost of public time and money. We must also question what should be the fate of complainants like Dr. Subramanian Swamy, who came to the court and then got disinterested.
This can't be a monologue.
Wait, ma'am. You have to be patient.
This is the frivolity of the BJP spokespersons. They want all the discipline.
No. Rajdeep is giving you unlimited time. This is not fair, Rajdeep.
I'm giving equal time. Sanju Verma, equal time. 30 seconds more. Mahima Singh, 30 seconds more. Complete your argument. I'm giving you 30 seconds more.
You see, the opposition has been claiming that there is vendetta politics, that there are 95% cases against the Congress party, against the opposition parties, of which the conviction rate is very well known. So I think, as I said earlier, this marks the commencement of a new era, the end of vendetta politics, because now the courts will teach, the judiciary will teach a lesson to the BJP, and the truth will prevail, as we have always maintained.
Okay, you're saying based on this one verdict, a new dawn will begin. But let me put some facts to you, to both of you and to our viewers. ED's PMLA probes, June 1, 2014 to October 10, 2025. Number of cases, 6,312. Convictions, 120. Closure reports, 93 since 2019. This is based on a government's reply in Lok Sabha. So what we are seeing is a very low conviction rate. We're seeing cases drag on, Sanju Verma, for years. The process is the punishment. And the fact is, Mahima Singh is right, more than 90% of the cases are against opposition leaders when it comes to PMLA. In that context, what the court has done will, as I repeat, give more ammunition to the opposition to say BJP is engaging in vendetta politics, using the ED as its weapon.
Rajdeep, you gave a free run to the Congress party. Now, I don't want you to interject me because you have this very bad habit of giving lectures to the BJP on patience. Sanju Verma showed decorum. I'm going to show decorum and patience provided you behave like a neutral journalist. I want to ask one thing. Have the Gandhis been acquitted? No. Have the Gandhis been given a clean sheet by the Delhi High Court? No. And you forgot to mention a very important thing, Rajdeep Sardesai, that the magistrate had said Sonia and Rahul Gandhi should be given a copy of the FIR. The Delhi High Court said that Sonia and Rahul Gandhi need not get a copy of the FIR from the Delhi police because this is an ongoing investigation. Very quickly now, wait for 30 seconds without, interjecting. Did the Congress party give an interest-free, collateral-free loan to the Gandhis? Yes. Did the Gandhis fail to repay 90.25 crore? Yes. Did the Gandhis take 76% stake in Associated Journals via a company called Young Indian? Yes. Did the Gandhis convert loan into equity? Yes. And did the Gandhis do all this within the ambit of law? No. You have not studied corporate finance.
all of this, all of what you've just said, madam, all of which you've just said, all of which you've just said, I've heard for the last 13 years now. The truth of the matter is, if this was a money laundering case where money laundering was proven, by now it should have gone to trial and conviction. That's my limited point. You've been saying this and I've been hearing this for the last 13 years. Where is the point which is made? You'll have to prove the money laundering.
Can I please finish?
Or profiteering.
Rajdeep Sardesai, let me just say one thing to you. What has Abhishek Manu Singhvi been saying? He has been saying Young Indian is a Section 8 company. Earlier it was called a Section 25 company, under which the directors do not get any dividends. The directors are not liable to get any salaries. But what Abhishek Manu Singhvi does not tell you, please read the 117-page verdict of the Delhi High Court, that Young Indian / Associated Journals Limited is not a non-profit company to start with. Has AJL or has Young Indian ever established a school, a college? What kind of social objectives were achieved? Have they done any charitable work? That is a question Rajdeep Sardesai will not answer. So tell me, I know what Azim Premji Foundation has done. I know what charitable work Reliance Foundation has done. Tell me the charitable work done by Young Indian is appropriating 5,000 crore worth of property by paying 50 lakhs as check. That too only a book entry.
Ma'am,
I've heard you. Way of doing charity. Tell me, I want to ask you as a journalist, you keep talking all of 12 years, 12
Madam,
years.
I've heard you now.
What is the charitable work done
I've heard you.
Mahima, what is the charitable work
all
done
of
by
this,
Young Indian?
all of this over the last 14 years should have led by now surely to some kind of trial and conviction, which has not happened yet. But Mahima Singh, the fact is the ED claims that the overall proceedings of crime exceed 5,000 crores based on the value of which 2,000 crores represents the value of Associate Journal Limited's assets. The probe agency says it's attached 661 crore of immovable properties, 90.2 crores worth of AJL shares. They claim based on a 2017 income tax order that there are 414 crores in alleged tax evasion linked to these assets. All of this has to still go through a process of law. I say the process may well be a punishment, but at the same time, there is no clean chit. A quick final answer.
And we have not denied participating. We have duly participated in the process of law. However, the BJP spokesperson's naivety is pitiable, Rajdeep, I must say. Because one question that, has raised eyebrows today after this verdict came out from a Delhi court is, if ED could not have proceeded without an FIR under the PMLA, then at whose behest had this case proceeded over the last 13 years, number one. Now, the other, other point of naivety in the BJP spokesperson's rhetoric was that she's talking about converting to equity. Let me remind her that converting debt to equity is a very common way to revive a company. And let me give her an example. The government of India did that. The government of India, please let me not make you take
she did not interrupt you. Sanju Verma, put a voice down. Sanju Verma, you cannot interrupt her. She did not interrupt you.
The government of India, Rajdeep.
Go ahead, finish up.
The naive BJP spokesperson must remember the government of India itself did the same thing with Vodafone. Banks have done it with Jet Airways. And unlike those firms, I must remind that AJL's restructuring led to resurrection of National Herald, Navjeevan and Qawmi Awaz, which are still running as rightful newspapers and are doing good service to the society. So the BJP spokesperson must educate herself well before speaking on such critical matters. She must answer critical questions before bringing the rhetoric to the surface.
There are still questions, of course, over the relationship between Young India and AJL. All of these questions, of course, will still continue to be part of an ED investigation. The problem, of course, is it's now 13 years, I repeat, 13 years since Dr. Subramaniam's private complaint, on the basis of which originally the ED investigation was carried out. My hair has grown grey by then, and we would hope that our legal system would at least ensure either way that we reached a finite conclusion. In the absence of that, we will always suggest, or there will be the suggestion, that this is a classic case where the process becomes part of the punishment. Sanju Verma, Mahima Singh, for joining me on my face-off. Thank you very much.